G'day, my name's Henry Davis. Today we're going to be talking about FCT versus McNeil, which is a 2007 case which was heard in the High Court of Australia. This case was a test case for 80,000 taxpayers at the time, and the amount in question was actually very small indeed, for about $600. So the facts of the case were there was a shareholder of St. George Bank, and St. George Bank wanted to reduce the amount of capital that it had by about 5%. So what it offered its shareholders was a 1-for-20 sell-back rights or a put option at a premium price of about 19%. So the value of the share was trading at about $13.90 when this idea that came out, and the St. George Bank was offering $16.50 for the under this sellback right, and would purchase your shares for significantly more money. Now, the idea by St. George was to reduce the amount of capital that it had and reduce the number of shareholders by 1/20th. So for every 20 shares that you owned, it would give you one sellback right that you could then trade in. There were three options for the shareholders. You could, one, exercise your rights and sell one of your shares, or exercising your sellback rights and sell one of your shares back to St. George for the purchase price of $16.50. You could sell your right, this sellback right, on the ASX and make a gain that way. And hopefully, St. George was hoping that somebody else would exercise that right. Or you could do nothing. Now, if the shareholder did nothing, then those rights would be transferred to a trustee who would then sell them for you and then distribute the money to you as a shareholder. So the question here was whether it was income, capital, or nothing at all. And the taxpayer was alleging, of course, that there was no income or tax payable, income tax or capital gains payable on the disposal of their sellback rights. The commissioner was arguing, on the other hand, that the amount of money was income in the hands of the shareholder. So in the first instance, the case went to the federal court, and the federal court found that it was neither income or capital in the hands of the shareholder. And their reasoning was to say that under the constitution of the company, it wasn't a dividend, it wasn't an available mechanism, and that this transaction actually happened by way of a deed poll, or a number of deed polls that happened outside of the control of the normal course of the company. And that's why no income or capital was payable, capital gains tax was payable on that transaction. The commissioner appealed that decision, and the High Court found that the amount was income and therefore didn't consider whether it was capital. So under our Tax Act, if something's found to be income, then you won't consider the capital, whether it's capital, following that. The decision wasn't unanimous, it was 4-1. And the reason was that the High Court found that it was income according to ordinary concepts under 6-5 of the Act. Mainly that they looked at seeing the interesting thing was, in the hands of the company, it was actually a reduction of their capital. Now, normally if you purchase shares, say if you buy $100 worth of shares and the company says, I don't need $100 anymore, so I'm going to give you $50 back, then that wouldn't be a capital gain or income, it would simply be a return of capital. But the High Court looked at it from the point of view of the taxpayer, who had essentially acquired a right, sold that right, and then derived income, and so determined that the taxpayer had derived under the ordinary concepts of income, under 6-5 ordinary income, and was therefore liable to pay tax on it.